Bishop is not here for me to verify it because, as you know, he's the only one who read the rules, that the new rules will invalidate the no-action clauses in these insurance contracts. Are you aware of that?
I'm in the same position, I think, as Doug Goudie said, is I don't know the rules at all either.
Yeah, I saw that in a bulletin, so anyone starting or considering starting an action against an insurer after January 2nd, 85 should consider that new rule or find it. Yes? Is there a procedure that one could follow if you think there is insurance and he's not notifying the insurer or have? I think the only thing we can do is to write directly to the insurer. In the case of lawyers, you know who it is, and in the other cases, it's very hard for you to determine. Maybe the new rules that Mr. Justice Montgomery referred to in the course of the lawsuit might assist you.
Barry, if I could, all right, there are two specific things directing specifically with lawyers' errors and omissions. Number one, you and I and everyone else knows what the limits of the policy are, because you can have it, it's your own policy. And number two, you may report to the Law Society Office of Director of Insurance directly. They can now take a direct report from the solicitor acting for the aggrieved client.
Well, is it proper to inquire of the person against whom you're making a claim whether he's reported it or not? People do that, yes. I've seen letters that counsel have written saying, have you reported this? Why have I not heard from another lawyer? Why are you still on the file? Yeah. I know you'd like to call it a day, but I'd like to just deal, for the benefit of those in the audience who have cases against me involving agents, I'd just like to deal briefly with this topic. I'll be very brief, I promise you. The insurance agent's liability. The leading case in Ontario is the Fines-Flowers case, the Court of Appeal decision. And it establishes the nature and the extent of the duty of the insurance agent. I'm going to deal with that. I'm also going to deal with the two other questions that arise that are related to this question, to this issue. What is the obligation of a client to follow up and see if his agent, who undertook to arrange insurance, to see if his agent has in fact arranged that insurance? What is the obligation of an insured, once he's received the policy, to read that policy to see if, to verify that it complies with his instructions? Is it contributory negligence if a client has not taken those steps? Back to the Fines-Flowers case. Facts very briefly. Greenhouses in Ottawa, mid-January 1968, I think. Very cold weather, and the heating system shuts down. It shuts down because of the operation of an automatic safety device. The reason the safety device clicks on is because two pumps, which draw well water, because of wear and tear, fail. So the pumps fail, the water stops, automatic system shuts down the boilers. Now, it so happens that the boilers are the only things that are shown and covered under the policy. The pumps are not. The case comes on before Mr. Justice Fraser, the late Mr. Justice Fraser. He dismisses the action as against the insurer, simply says that there's no coverage. The pumps were not covered. They were not objects in the policy. And in any event, there was an exclusion for wear and tear, and this was clearly a situation of wear and tear. He finds the agent liable in contract because the case was pleaded in contract. He finds liability in contract. He says he would have been just as ready to find liability in tort on the basis of a special duty arising from Hedley Burn. For those of you who are acting for plaintiffs, there are fantastic statements, very broad statements of principles in this case, and you'll take comfort in them. For the people who are acting for the agents, they'll want to distinguish the case on the facts, Mr. Singer. So, you have to, for that reason, we should look very briefly at the three key findings of fact And they're at the bottom of page 1 in the paper that I prepared. Finding 1, there was a very close continuing relationship between Mr. Fine, that's the principal of the plaintiff's company, and Mr. Campbell, the agent. Finding 2, the plaintiff had relied on Campbell, the agent, to arrange adequate insurance, full coverage. That was the understanding, the undertaking. Finding 3, and this is of critical importance, it was discovered that there was in fact a letter from the insurer to the agent inquiring if there was any intention to insure these pumps. And the agent had more or less filed that inquiry in his file and had not pursued it. So those very key findings, I think, had an obvious influence on the court, both Mr. Justice Fraser and, on appeal, Madam Justice Wilson, as she then was in our Court of Appeal, who delivered the judgment, concurred in by Mr. Justice Blair. She said that as far as this case was concerned, it was a clear case of breach of contract. There was an undertaking by the agent to cover the plaintiff for all foreseeable, insurable, and normal risks. That's a very broad undertaking. And by failing to insure against insurable and normal risks, there was a breach of contract, and therefore damages were to be assessed. She also said that liability could be sustained in tort on the same basis as Mr. Justice Fraser had determined. Chief Justice Esty, as he then was, when he had problems finding liability in contract, he thought you'd have to work very hard to find liability in contract. I think the trend after this was a case decided in 73, I believe, 77, is to find liability against an agent in contract. But I just want to mention to you, Esty, Chief Justice of Ontario, had doubts about it being in contract. He said he'd find liability in tort and also possibly in equity. And I've outlined in my paper his thoughts about that. The duty that was discussed in that case, twofold, and this is key. There's really two duties. The first one, the agent must exercise reasonable care to obtain the policies on the terms bargained for. Secondly, and this is the more significant duty, the agent must advise his client if he's unable to obtain the coverage he promised to obtain, or if it's not available. And the reason for this second duty, or this second aspect of the duty, is that the client, if he's given instructions and the agent has not complied with those instructions or has found he cannot comply because that insurance is not available, has to give the client the opportunity to take other precautions, whether it is buying out of an exclusion clause or taking other safety precautions, as may have been relevant in this Fine Flowers case. Two distinct situations that would be applicable with respect to agents, and the impact of these two duties vary in the two specific situations. First, client comes to an agent and says, I want a specific type of coverage. I want SEF 42 coverage, very specific coverage. Duty of the agent, get the coverage, and if he can't get it, tell the client, I haven't got it for you. Second case, and this was the type of case that Fine Flowers was, is a broader undertaking. No specific instructions. Very common. The plaintiff simply relies on the agent to see that he is protected. He simply says, I want to be covered. Make sure I'm covered, I'm insured. Full protection. If the agent agrees to do business on those terms with the client, that's his problem, and he's assumed a heavy onus. If this requires that he must inform himself about the client's needs, he must do so. That's his responsibility. If he has to inform himself to assess what the reasonable, insurable, foreseeable risks are for that particular client, he must do so. That's part of his duty. And Madam Justice Wilson, if I may just read from the notes from her decision very briefly, puts it this way. First, as to the duty. She says, as for the scope of the agent's duty, this is on page 2, third of the way down, the agent's duty is to exercise reasonable degree of skill and care to obtain policies on the terms bargained for and to service those policies as circumstances might require. She says, I take no issue with counsel's statement of the scope of the insurance agent's duty, except to add that the agent has a duty to advise his principal if he is unable to obtain the policies bargained for, so that his principal may take such further steps to protect himself as he deems advisable. And then, dealing with those two situations that I described to you, the specific coverage request or the broader undertaking to insure generally, there's a lengthy quote, again at page 2 of my paper, where she emphasizes that broad undertaking, and she quotes from a decision of Mr. Justice Haynes as to what the solution is. I mean, what's the agent to do? Is there too great an onus being placed on him? Mr. Justice Haynes had said the solution lies in the intelligent insurance agent. That's an unusual test. The intelligent insurance agent. The solution lies in the intelligent insurance agent who inspects the risks when he insures them, knows what his insurer is providing, discovers the areas that may give rise to dispute, and either arranges for the coverage or makes certain the purchaser is aware of the exclusion. It's a fairly broad duty. Now, let's go back a little. Fines Flowers had a very simple defense. The agent's lawyers argued, all right, let's assume we failed in our undertaking, but there was an exclusion applicable. It would have been applicable in any way, in any event. Wear and tear. This is a clear case of wear and tear. There should not be any recovery. The court, unfortunately, was not satisfied that you could not buy insurance without that exclusion clause, without that wear and tear provision. But in any event, and this is somewhat unclear in the decision, Wilson J.A. said, moreover, in any event, if an agent is unable to obtain insurance for his principal in accordance with his instructions, he's under a duty to report this to his principal. He cannot stand by and let his principal assume he's covered. Still less can he lead him to believe that he's covered. So it seems that even in the case where there is a defense of an exclusion established, that a standard exclusion would have been applicable, there is still a very serious potential liability can be found against an agent if he's not reported back to his clients. Keep in mind an interesting case out west of Martin. I've cited it there. In that case, the defense of exclusion was made. It was an insurance agent who had promised to cover a crane. He had not covered the crane. The usual exclusion is overloading in that situation, and in this case there was evidence that the crane had been overloaded. The court said, relying on an English decision, Fraser and Furman, that the loss still had to be assessed, even if it were satisfied the exclusion would have been applicable, because a reputable insurance company would have settled that case on a 50% basis and awarded damages to the plaintiff for 50%. Lost opportunity to negotiate with a reputable insurance company. I mentioned that to you as an interesting approach that you might take if you're acting for the plaintiff. Let's go on to the other two duties that I mentioned, that I want to explore with you, see if they exist or not. The duty of the agent, of the client, if any, to follow up to see that the agent has performed his undertaking. This was reviewed by Mr. Justice LeCourcier in the recent case of Cousins and Smith, and I've cited that in the material. He said that the client does not owe the agent such a duty. It is not contributory negligence not to follow up on the agent. What happened very briefly in Cousins and Smith was there was again a greenhouse incident. A farmer who had quite a bit of insurance business with his agent, paid him about 5,000 premiums every year, asked the agent to insure his greenhouse after a storm. The agent said he'd insured it. He said he'd insured it, and in '78, some 3 years after this request for insurance, he represented that there was insurance coverage. And I mentioned that to you because, again, if you're acting for the agent, you may want to use that fact, that representation made subsequent to the original undertaking to insure as a basis to distinguish the case. The case came up in front of His Honor Judge McDermott in the county court, and he found that there was no contract. I don't know how he came to that conclusion, but he said there was no contract. But he said there was negligence, but he found that the client was 75% contributory negligent because he hadn't followed up to see where the policy amendment was, where the endorsement was, why he hadn't been requested for a change in premium. He had not paid any premium at all. Lacourcier J.A. took a very, very simple approach. He said there was a contract. There's no doubt about it. I asked you to arrange insurance. You said you'd arrange insurance, mutual promises. I relied on that. There was no doubt about the contract. He then considered the two questions that I set out about a third of the way down on page 6. He said, two substantive issues arise in this case. Number one, whether apportionment of liability as a matter of law is available in breach of contract actions as against negligence actions. Secondly, whether the finding of contributory negligence by the plaintiff could be supported in law. He was inclined after reviewing a recent decision of Saunders J. that I've cited there, he was, I think, inclined to find that you could have apportionment of liability in contract cases as you do in negligence. But he felt it was not necessary for the Court of Appeal to rule on this because there was no basis at all in law for finding contributory negligence on the part of the client. And for that principle, he relied on a principle stated in Halsbury, which reads, very simply, every agent is responsible to his principal for any loss occasioned by his want of proper care, even though the principal has himself been negligent in not discovering the agent's breach of duty. So it appears there is no duty on the part of the agent to check up on the part of the client to check up on the insured. Is there a duty to read the policy? In most of these cases, in the Fines Flowers case, clearly the insured had received the policy and he hadn't read it. Nobody reads their insurance policies. Here's a case that I've cited where the judge says, halfway down on page 7, the court said, I doubt whether one insured in 100 reads a policy on receiving it. That's true, isn't it? Who's read it? Going down in that case, there's another observation that's very interesting, and that is, this is a very interesting observation. In my view, the court says, those comments are even more applicable, these comments that are quoted there, to documents delivered for retention, such as insurance policies, than they are to documents submitted for signature. In principle, then, when you're dealing with a lawyer, a banker, or an insurance agent, you're entitled to trust that agent. You as a client, for now. You're entitled to trust the agent. And in particular, with documents given to you for retention rather than signature, you can assume that your agent has acted in accordance with your instructions. There is no duty in Ontario today, I submit to you based on the authorities, for the client to read the policy, to verify to see if in fact the agent has performed his undertaking.